There's an important decision handed down this week there from the Court of Appeal. It's to do with a personal injuries case. And it's a decision that's going to have implications right across other personal injury claims perhaps in the future, and it might impact how PIAB actually do their work, do their business, assess claims. Basically, this involved a case where a woman brought a claim. She was working in a hospital. I think she might have been a cleaner, but an oven fell on her and she suffered a personal injury. She brought a claim, but the personal injuries or the injuries she sustained were relatively minor insofar as they seemed to be mainly soft tissue injuries. But they arrived at PIAB, the Personal Injuries Assessment Board, arrived at a figure of €11,000 for her injuries. And the lady in question wanted to know how the €11,000 was arrived at. And the Court of Appeal, a 3-judge appeal court, said the basis of the calculation of the 11,000 of the assessment by PIAB is a matter of critical importance to a claimant. And the reason for that is because when a person receives an assessment from the Injuries Board, they must decide to either accept it or not accept it. And if they don't accept it, then they have to go to the civil courts and bring legal proceedings, etc., which can be a costly affair and which obviously can result in costs being awarded against the claimant. So it's an important thing to understand how the amount was arrived at. And basically the court said that claimants are entitled to be given information sufficient to understand the basis of its calculation of general damages without having to resort to guesswork. That's what the court found. The degree to which PIAB must explain its assessment may vary from case to case depending on the complexity of a person's injuries. But it should, according to the court, be reasonably clear how the board arrived at the particular amount. It is clear the court held that PIAB considered the medical reports and the guidelines in relation to this lady's injuries. If her injury, Miss Wolf, only injury was to her back, there could be no doubt that the assessment, when read together with the medical reports and the 2021 personal injury guidelines, would constitute a sufficiently reasoned decision. However, her only injury was not to her back. PIAB assessors concluded that the back injury was her dominant injury and fell into the minor category, which covers awards up to 12 grand. The assessors said the back injury should be assessed at the top end of the minor category, having regard to all the medical evidence and to allow for the lesser injuries. However, the judge added that some of the assessors' references to Miss Wolf's lesser injury or injuries were generic, providing no information at all as to how these were taken into account or how much, if any, of the 11,000 general damages related to them. So the question here is, the Injuries Board identified that she had suffered a back injury and suffered soft tissue injuries, but she wasn't given any information as to how much the value they put on the soft tissue injuries, the general injuries, as opposed to the back injury. PIAB had a fear then about a more detailed approach, but the court held that those fears were entirely unfounded, and the matter could have been resolved with one simple sentence, setting out separately the value of the dominant injury and then the general damages, including the lesser injuries. So the dominant injury in this case was the back, the lesser injuries were the soft tissue, etc. But the figure of 11 grand didn't differentiate or discriminate between the more dominant injury and the lesser injuries. The High Court had refused to quash PIAB's assessment of Miss Wolf's injuries, as it said the assessors would only have to provide a more detailed explanation if they had departed from the 2021 guidelines. So the case arose from an incident in a kitchen at the Mater Hospital in Dublin. Miss Wolf alleges that a heavy oven she was cleaning fell on top of her due to it not being properly secured to the wall. She claims she had to support its weight for about a minute before managing to push it from her torso. the three-person court said that she was entitled to her legal costs or legal costs in the High Court and the Court of Appeal. So this is an €11,000 award from the Injuries Board to Miss Wolfe. She went to the High Court and then she went to the Court of Appeal, and she now has had her costs awarded to her. The court said that it would quash PIAB's assessment and refer her claim back to the board for fresh consideration. So the Injuries Board have to give this fresh consideration, and basically they're going to have to give some explanation as to how they arrive at the figure, so that the person is able to make an informed view as to whether to accept or reject the assessment. This decision will have further implications because other persons now will be in a similar position, and the PIAB will have to be much more careful in how they arrive at their decision, but not only how they arrive at the decision, more importantly how they explain the amount that they've arrived at to the claimant. And just to note, it is open to the Injuries Board to appeal this decision to the Supreme Court. Whether that happens or not remains to be seen. If you are watching this on YouTube, I'd appreciate if you hit the like button and perhaps consider subscribing to my channel. If you're listening to this on a podcast, either on Spotify or iTunes, wherever, you might also consider giving me a review and subscribing.